Indeed. So let's start. I would like to welcome. I haven't had the word so far. So from me, also a very warm welcome to all of you who are joining now at this moment, or who joined us already for the morning or afternoon, that depending on your time zone. So a warm welcome from me as well to this conference on inequality and the role of competition law. And a special welcome to our keynote speaker, Professor Eleanor Fox. Thank you for joining us today and sharing your thoughts with us. For those of you who may not know Eleanor, she is a professor at NYU in the United States, and she's truly the person who has been working on these important and urgent issues already for many years. So while some of us are just stepping into the branding issues of what is inequality has to do in competition law or economic regulation, Eleanor has been working on these issues with regard to developing countries, and also not only issues of inequality, but also with regard to poverty, how opening up markets in countries may have an impact with regard to corruption, chronism, marginalization of people. So we are very happy that you are here today, Eleanor, with your co-author, and that you will share your research and your thoughts in a historical and comparative perspective. So thank you for joining us, and I give you now the digital floor.
Thank you so much, Kati, and thank you, Kati and Jan, for this really stupendous conference exploring the inequality issue and antitrust. So my co-author is Philip Bazanov, and Philip is here today, and today actually is getting his LLM degree from NYU Law School. He is my student as well as co-author, which is very nice for me. And oh, so I see you, Elias, you're just flashed onto the screen, and I want to say, as a sort of, I regard you as a past student, although you were really visiting scholar on a very high level. But it's lovely to see you again, and to see also that we are dealing with some of the same issues of history and equality. So I will start now on the remarks that I would like to make. And I have slides already on the screen, and we are all dealing with the same question posed on the first slide: the extent to which the serious, persistent, growing inequality of wealth and income is a competition concern. I add without mobility, because there is also in our societies very little mobility. If there were mobility, it would be of another dimension, much less serious. I will give a little background and tell you why we, when I say we, it's Philip and me, so why we decided to investigate history and its evolution with respect to the inequality issue. And then we will give you our findings from history from 4 specific market studies. And we offer a little more comment on some other countries, and then some recommendations and conclusions. For a background slide, I simply wanted to note that this inequality problem is so horrendous and getting worse. And getting worse, this is an article from 2 days ago in the Wall Street Journal, the inequality virus in developing countries, given the coronavirus, with so many people falling newly into poverty, without food, without water, without shelter, without education opportunities. The problem is enormous, unfathomably so. And then just a word about links, because there are many links and assumptions, or maybe research that must be made to link the inequality problem to competition. And I'm not delving into those links, but want to make one observation that the source of inequality is actually really important. And it's not totally clear the extent to which business concentration is the driver of inequality. And many people think that it is technology with globalization that is the big driver of inequality, and the changing nature of jobs and the availability of jobs with mostly only very high skill that is pushing many people down on the inequality continuum. However, we think that answering all of these issues of links is not necessarily important to get to the next question that we've been discussing, which is exactly the relationship between inequality and competition, and how possibly to use competition law to be much more friendly to the inequality problem. And to say why, I just want to reflect. This is, again, it's reflection on links first. It seems that, and this I agree with Piketty, it seems that the market system produces, and it tends to produce, more and more inequality. At least when the market system starts to produce market power. As soon as it produces market power, it is producing a spread of wealth, income, and opportunity that plays into the hands of the elites and those who are already better off with, for example, money and skills. And as soon as we recognize that simple statement, which I really think is not very controversial, as soon as the market system produces market power, it plays into the inequality hand. It is, and then there is antitrust to try to contain the market power, but it doesn't do so perfectly. With that simple statement, we can see that there is a role for antitrust to play. To see what the role is, and to see practically, as a practical matter, how big and robust that role can be. We thought that it's very important to look at the history and evolution of equality, and to do so in a range of jurisdictions, because we think that the problem tends to be specific to jurisdictions in terms of what antitrust can do and can be expected to do practically. So we look at the relationship. We ask what has worked, and given what has worked and how the jurisdiction has or has not accepted the equality value into its antitrust jurisdiction, what we can expect the jurisdiction to do in the foreseeable future. I'm going to go briefly into the 4 jurisdictions we selected. What we wanted to do was to ask the question, is equality a part of this law? And to do that, we actually did searches of equality, inequality, etc., and the antitrust law of the jurisdiction. But it isn't always a function of mentioning the word equality. Excuse me. Because there are a lot of first cousins to caring about equality. And those first cousins include, the first one is just so intrinsic in even why countries have antitrust, anti-power. Antitrust has historically been, at least before certain technocrats get a hold of it, it's historically been anti-power and for democracy. and Elias, I know you've written a lot about this, and for outsiders, not insiders, for those who don't have power against the incumbents and the privileged firms, so that antitrust always, in at least most jurisdictions, has had a relationship to the inequality value. To do our research, we looked at various things in each of the countries and jurisdictions. We looked at the jurisdiction's treatment of small firms, of workers, of the fragmented little guy against the big, powerful source. And then we asked a set of questions, which I'll boil down to 4 right now, as to each jurisdiction. Is inequality value embedded? Number 1. Number 2, is it nonetheless used as a source of wisdom, sometimes top down, sometimes for priority, sometimes for tiebreakers? Number 3, is it used, for example, to help workers who would be displaced as conditionality for mergers? And number 4, is there an affirmative action component to help those who have been left out? And you will see as I go quickly through our 4 country studies, we have US, EU, Germany, and South Africa, that US and South Africa are like bookends at the other side of this problem. With US today disclaiming any non-economic value, and Africa trying South Africa, as hard as it can to see how it can use antitrust for greater equality. For US, here is a very famous picture, but it is so clear that from the outset in 1890, competition law was essentially anti-power of those big billionaires who had gotten their money off the backs of the people. That's wealth, power, inequality. The value of equality of opportunity comes up in a huge set of cases ending in 1977 and with a vengeance in the Reagan administration in the early 1980s. So US had 2 periods of time, the one in which antitrust was really deontological. We weren't trying to maximize something like a certain notion of welfare. We were trying to advance certain values where the outsiders had an easier, clearer way to get into markets on the merits, and the consumers were reciprocal to that, because as more people got into markets on the merits, the consumers would get the better deal. This abruptly changed in the United States to period 2, and we are in period 2 now. And in this period 2, our antitrust could be called libertarian antitrust, and the type of freedom that is maximized is freedom from government interference, and this whole bunch of assumptions that come into antitrust from that ideological posture, but some of which are true or almost true, not all, that markets tend to work very well. Sometimes that's true, often it's not. That firms, when they are taking single firm action, this means monopolization as opposed to cartels, that firms have to respond to what consumers want because that's how they make their money. And so especially in our Section 2 Sherman Act monopolization jurisprudence, there's a very strong presumption that what the firm does is good for consumers and good for the market. In the United States, it's pretty clear, looking at the law as it is and the Supreme Court as it is, that means not looking at Lena Khan and New Brandeis Movement and Amy Klobuchar. Looking at the law as it is, the US antitrust law is allocative. It allocates resources. It is not distributive. The vocabulary of bringing the distributive values to the table is not kindly received. One is outside of the mainstream conversation, which isn't bad, but I'm talking today about what we can expect to happen, and for US, even given the law before any amendments, legislative amendments that might or might not happen. I have to do this really so quickly that I will do a caricature. So the competition law of the European Union does not have the Chicago School presumptions. And their markets actually are stickier and more barriers and more, at least historically, state-owned enterprises with privilege. So the lay of the land on top of which they put competition law was quite different, especially in the 1950s, and still different today. And so while they have law that is, well, you mostly, largely allocative, there's not the animosity to talking about the distributive concerns. And the very fact that for EU competition law, there are some basic underpinnings of open valuing, openness of markets, level playing field, responsibility of dominant firms, shows the symbiosis of an equality value with European Union law. So here for Germany, and here I especially have to thank Philip, who is from Germany. Germany is competition law is very influenced by ordoliberalism and influenced by roots up, whereas EU is taking in a way a conglomerate of values and inputs and has to impose it on the member states. The German law has a very strong enterprise against power to begin with, and certainly not at all against thinking of redistribution, and indeed in its law, abuse of superior bargaining power is a redistributive value, and it's very much highlighted in the German competition law. And last bookend now is South Africa. And I do want to thank in advance Firas and Alex, and I have to read your paper again, and perhaps we have to modify ours in view of your insights on South Africa. One thing, several things so clear about South Africa and why it's so important in this conversation is for the new South Africa, when it adopted its competition law, equality, getting transformation of society so the left out majority would at least be more nearly equal was like #1 on the list. So one could not disregard the equality factor as being, oh, that's distributive and inconsistent with competition law. Competition law is meant to empower. And there are new amendments that go further than the law as it was of 2018, amendments of 2018 that put more equality into the competition law and that press forward even with what I am calling affirmative action for the left out to try hard to get more of the transformation South Africa needs. So in terms of our 4 country jurisdiction examples, These are our findings, more or less, although we have a lot of detail on each of the jurisdictions. First, just terminology. When equality values are expressed in the laws, it's mostly and even almost all equality of opportunity. Sometimes wealth and income are mentioned, very seldom and almost as throwaways. I don't mean throwaways, I mean as byproducts. But equality of opportunity is built into the law. It was US first half of the law, and in most other competition laws. And it is on the theory that people who are not the people with power ought to have a right to contest markets on the merits without being set back by roadblocks by those who have power. And also has a distinct relationship with empowerment of people. The more people without power are empowered, the more you can expect them to get of the share of wealth and income. And by doing it without redistribution, because you can think of it as allocative as well as distributive, it's a dynamic factor that fits or should fit together very well with what are the factors that make markets work well. And if you put it that way, it's dynamic and has allocative aspects and should be incorporated. Okay, so for our jurisdictional studies, what did we find? Well, I've already telescoped that. For US today, given the law today, and our Supreme Court today, equality is not an embedded value in antitrust. It used to be. It got wiped out entirely from between 1977 and then early in the 1980s. So it is, the law is a hostile workplace to equality. In South Africa, so embedded, and in the other two jurisdictions, we say embedded because of those relationships we've mentioned. Is an equality value used to prioritize, to break ties as source of wisdom? So US, no, although it can be by enforcers. And our Federal Trade Commission, for example, clearly it can be, will be used by them, despite the fact that cases brought might not get won. And definitely is there as a possible source of wisdom. Is it used in merger clearance conditionality? And here's where I took the lead from South Africa, because South Africa does this systematically on merger clearance conditionality to help those who are the losers from the competition game, not in any other jurisdiction as far as we can tell. And then does the jurisdiction's competition law alleviate inequality or aggravate it or just do nothing? So here's where US is interesting negatively. Certainly doesn't alleviate. It certainly just does nothing, but it actually could be said to aggravate because of its disregard. So we think that these elements can and should be used in each jurisdiction separately in considering how receptive is the jurisdiction, what is the next step that's possible and practical in the jurisdiction. So this is actually my last slide, almost last slide, next to last slide. And Kati, how many more minutes do I have for, I have like 5 more maybe?
Yes, you can have the go ahead. So we are fine on time. Okay.
All right. So here are a few recommendations that come out of our study. That there is, in fact, a deep symbiosis of what we'll call good competition law and narrowing the inequality gap, And in fact, there is a symbiosis even for a hostile jurisdiction, because I'm calling that US, because when competition law does its job to contain market power and those places where it's invited to, like bad conduct or mergers, this is an element that points in the helpful direction of pushing back on the growing inequality gap. But for those jurisdictions that are hospitable, one can see the symbiosis is very deep. Number two, there are various steps that should be taken for better competition law enforcement and for inequality reduction. And several of you have mentioned this, and it's floating throughout, we need better antitrust. It's not always saying get rid of Chicago school and we get rid of allocative antitrust, because there are many levels of use of economics and in the United States that are not Chicago school. And what I'm talking about in this recommendation, what we are is pure antitrust that's within the antitrust paradigm that doesn't mention inequality. We need to get better control over antitrust prohibitions against the creation and entrenchment of market power. We need to enjoin anti-competitive mergers. They're almost all let to go through with some package of remedies, and the big guys are huge or allowed to merge. We have to rethink what is substantial market power. So the relevant word in US is monopolization. It is a threshold that is too high, and depending how the market is defined, which is sometimes done instrumentally, it can be almost impossible to catch the power that we see, for example, on big tech. And then words of abuse of dominance are important. Substantial market power is actually coming into the foreground because jurisdictions are realizing that some of the words, certainly monopolization, are putting real problems away from beyond the grasp of antitrust. All right, number three. There is some terminology that we really should change and could be done everywhere, including US. And here I want to refer to use of Calder-Hicks and use of aggregate consumer welfare. Calder-Hicks, if the winners win more than the losers lose, that's efficient. And you never looked, I mean, the losers are never paid off. The winners could pay off the losers, but they never do, of course. And this totally obscures who are the losers. Aggregate consumer welfare does the same thing. I put in the word aggregate, but that's what it is. You add up all the dollars, not all the people. That means people with more money who buy more things get more votes. Both of those concepts actually do some work in the marketplace, efficiency, competitiveness. I don't mean get rid of the terminology entirely, but I mean also adopt a terminology that allows you to look at who are the winners and who are the losers. There are some antitrust rules that would probably be written differently if you ask about how many people lose out compared to how many people win. And also if you ask, and I thought that was interesting about the CMA case, they did ask about what's happening to the poorer population. And of course, South Africa, and this especially when David Lewis was in charge of the tribunal, looked to see this: who are the winners, who are the losers, who are the poorer population, are the historically disadvantaged people losing out. That's important information, and we're just not even getting the information. And my next point here on distribution is particularly relevant to the US, because I think US might be the only jurisdiction that says, don't mention redistribution to us, you're going to shrink the pie and everybody will be worse off. This is only allocative. And therefore, if the terminology is not such that someone can conclude and say, oh, you're using antitrust to redistribute, that's helpful. So this is my point, that it is the powerful predatory firms that are doing that redistribution. They are the ones that are taking money from, say, the poor or consumers and distributing it to themselves. And in a large sense, antitrust is correcting this predatory redistribution. Now, of course, it's true, antitrust in jurisdictions, especially South Africa, does more clear, simple redistribution, and fine. But I think we ought to recognize that in a lot of these cases, there's an allocative problem that happens to result in the redistribution. So finally, and I have to tell you, Philip, I just added this today, and it comes out of the South Africa paper. I mean, it was suggested to me by reading your paper, Firas and Alex. Competition agencies should do impact statements on the distributional consequences of transactions, mergers that probably have those distributional consequences. I don't really propose this to, or don't necessarily propose it to the US authorities. I would have to think about where it fits in the scheme of things. But there are equality-friendly jurisdictions that probably would take up that challenge. So those are our principal recommendations. And in our conclusion, we say, don't overestimate what competition law can do. There is this huge inequality gap that is growing every day, and technological changes are driving a lot of it. But number two, do not underestimate what competition law can do. Competition law can do things that nobody else and no other system can do. Competition law can give free, fair access to a market, and it's no alternative to say, oh, you should just tax a company more. Competition law in jurisdictions where they do have excessive pricing prohibitions can help poorer people get the medicines they need when, for example, Aspen has just raised the price by 2,000 percentages, and to come back and say, oh, we should just tax Aspen more in the tax system, does not do that work. So don't underestimate. Picture us in a long, narrow crew boat with many pairs of oars. We are rowing towards a better society. Antitrust is just one of many pairs of oars. We must do our bit to row in the right direction, and every rower helps. Thank you.
Thank you.